Today we're being joined by Charlie Bullock from the Institute of Law and AI. You're a senior research fellow there. Before we begin, could you briefly introduce LawAI and yourself?
Sure, yeah. So like you said, I'm a senior research fellow at LawAI. LawAI is a nonprofit think tank based in the US. We do research and consulting. About 70% of our work is peer research, which we generally publish publicly. And the other 30%, which is I think where most of our impact comes in, is consulting or advisory work, which could involve producing some legal research on important AI governance topics for frontier AI labs, or it could involve advising legislative offices on bills and so forth, giving our opinions on legal issues that come up there, and then other think tanks, et cetera. But one of our research things that we do that I've been doing recently is whistleblower law. I tend to focus most of my research on U.S. administrative law topics, but I also have a smattering of other interests in U.S. state and federal. Whistleblower law is one of them. I recently published a blog post, which I think you read, on how to design whistleblower legislation in the U.S. And I've been giving public commentary and so forth also on the AI Whistleblower Protection Act, which is a bill introduced in the U.S. Senate by Senator Chuck Grassley, which we're very excited about. So to talk to you today.
Nice. So I think before we actually get into any of the law of it would be nice to have some context as to what it means for someone to whistleblow. So if I'm an employee in a frontier AI company and I think there's a problem with something, could you go through my journey of how I would whistleblow? What are the issues that would come up? What are my options as a whistleblower?
The first thing that you can do, right? Let's assume that you're in the United States, right? Because there are some frontier AI lab employees in the UK. Of course, Google DeepMind is an important AI company, but it's owned by a California company, Google, and the rest of what I would consider frontier AI labs are in the US. In the US, you can do a lot of things if you're comfortable with having consequences for them, right? So you can do what whistleblowers often do and just go to the press with what you have. And the thing is, you might have contractual obligations, or in some case, other legal obligations not to do that, right? Like, it might be against the law if, for example, you're revealing your company's trade secrets. Misappropriation of trade secrets is in the US, and I assume elsewhere, crime, not necessarily crime, but at least a civil wrong, right? You can be sued for that, and less often you can be prosecuted criminally for it. You can do that. You can anonymously what to a newspaper or something like that, to a reporter, or post it publicly if you want, right? That could be a violation of your contract with your employers, right? A non-disclosure agreement or something like that. It could also provoke these trade secret type problems, but generally you can do those things, and people often do, right? And if you don't get caught, if no one knows who you are, then maybe you get away with it, right? The thing is that in the US, mostly people are employed on what's called an at-will basis, which means that pretty much you can get fired anytime for any reason, right? As long as it's not illegal, right? They can't fire you, for example, for your race or gender or something like that. That's against the law. But unless it's specifically against the law, generally most employees can be fired for anything, including blowing the whistle, right? Now, there are sometimes specific laws that prevent that firing from happening, that prevent retaliation in any form against whistleblowers, which would include firing them, which would include demoting them, reducing their pay, reducing their hours, hostile work environments they have to quit or something like that. These are all sometimes prohibited by whistleblower laws, right? So whether it's prohibited depends on the law of, first of all, the federal government in the United States, and second of all, whatever state you're in. Most frontier AI companies are located in California, and California has a relatively strong whistleblower law by US standards. So if you report a violation of the law, of any federal or state law, rule, or regulation, if your company's been breaking the law or breaking some sort of regulation, if you report that to the government, to the proper government authorities as specified in California's law, you cannot be fired for that. And if they do fire you for that, despite not being allowed to, you can sue them and either make them rehire you or get damages, etc. Basically get compensated for your loss. That doesn't apply to every state. Some states in the US have no whistleblower protections at all, right? Or only common law whistleblower protections. Common law being, in the US, as I believe in the UK, it's a judge-made law, right? Legal decisions handed down by judges, which establish precedents, right? There are sometimes common law protections saying, okay, as a matter of public policy, just because essentially it's good for the public's interest, even though there's no law in the book saying you can't retaliate against whistleblowers. In some extreme situations, the court will punish you for firing a whistleblower anyway, saying, hey, I know you're allowed to do this by the law, by the written statutory law, but it's against public policy, so we're not going to let you do it anyways. That can happen occasionally. So that's sort of the landscape of whistleblower protections against retaliation. But keep in mind that a bunch of important whistleblower cases don't implicate these at all, because it's not about maybe they're not reporting to the government, or maybe they're reporting publicly. Usually that's not protected by whistleblower laws in the US. It can be, but usually it's not, right? And then as far as federal laws go, there's currently no overarching federal whistleblower protection law in the United States. There are some for specific industries, right? If you're a railroad worker in the US, there's a federal law protecting railroad worker whistleblowers, right? And there's federal laws protecting people who blow the whistle about securities law, right? Securities fraud and stuff like that. And so it has been suggested, including by me and my colleague, Mackenzie Arnold, that we need a overarching federal standard protecting AI whistleblowers because of the importance of the issue and the sort of unique value to the public of having information about dangers arising in this industry.
Yeah, thank you for that. That was really comprehensive. I think one thing you kind of pointed out in the beginning was at the moment in California, whistleblowers are only protected if they are blowing the whistle on something that is criminal or against the law. Well, not criminal, but just against the law. And I guess that brings us on to the point of a lot of AI and tech somewhat is laxly regulated or not regulated yet. And so some things that whistleblowers would want to make a disclosure about won't be legal.
This is an important point in my view, right? Academics who study the history of how emerging technologies are regulated, talk about something that's called the pacing problem in the literature. But essentially, technology develops really fast, right? And laws tend to develop quite slowly, right? Over time, it's like a gradual process of building up your legal system. So when you have a brand new technology like frontier AI, right? Like the current top of the line LLMs, which have not been along very long at all, right? I mean, I've been working in the field 2 years. Really good LLMs have been around for not much longer than that, right? So our laws are not yet caught up to where they need to be to regulate this technology. I think everyone agrees with that, even sort of libertarian-minded people who think we should have very few laws. If you believe that there's a non-zero amount of regulation that's needed, what we currently have in the US is more or less zero, right? Not quite zero, but pretty close to it. So there are all sorts of things that can happen at frontier AI labs that might not clearly violate the law or any regulation, but that might just be because the law regulation hasn't caught up yet. There is no law or regulation to be violated, right? So I think what I recommended in my blog post about this issue was a standard that we have in the US and several other areas, which is a substantial and specific danger to public safety or public health, right? And I added national security as well. Substantial and specific danger to public health, public safety, or national security, right? What that does is it eliminates complaints about stuff that isn't that serious, right? Minor things. We don't want to interfere with freedom of contract too much. It's an important value in the US, right? If you sign a contract, we want to hold you to it. So if you sign a contract saying, hey, employer, you can fire me for whatever, we want to generally let them fire you for whatever. We don't want to interfere with that too much. But we'll interfere with it for important reasons of public safety. That seems reasonable, right? If we're protecting a very important public interest, we'll screw with your freedom of contract a tiny bit, right? So the substantial and specific part, right? Specific gets rid of complaints that are about like vague future harms, right? People talk about doomers, right? I've been called a doomer before on AI stuff, right? You're worried about the Google employee, right? I think his name was Lemoyne, like Blake Lemoyne or something, was this guy who said that, whatever it was, Bard is sentient and it deserves human rights or something like that, right? Which in my opinion is a pretty silly view, but he can have that, whatever. Lots of people have lots of silly views. I'm sure I do too. This was in like 2022, I think he did this or something like that. So stuff like that, where you're like, it's very speculative and far off, and you're not pointing to any specific harm, I think doesn't necessarily need to be covered at this point in time, because it's not that actionable, even if you did have it. If something's not substantial, if it's not a really big, significant harm, it's not worth interfering with freedom of contract about. So that's the standard I suggested, is that in addition to violations of law, substantial and specific dangers should also be able to be about by AI employees. And there's precedent for this. There's other areas. The Whistleblower Protection Act in the United States applies to all employees. It doesn't apply to private employees, so most doesn't apply to most frontier AI company employees. But if you work for the U.S. government, the federal government, then you can blow the whistle on substantial and specific dangers to public safety, even though law has been violated, right? It shows up in other U.S. laws for various industries as well. But I think it's a good idea to have that for AI as well. And in the bill that's been proposed by Senator Grassley, they adopted that language, substantial and specific danger to public health, public safety, or national security, as sort of a gate, which I think makes a lot of sense.
Cool. Okay, so now that you've introduced us to the new bill, could you talk about what the bill proposes, and talk about like the different scopes of what protects a whistleblower, what is considered public interest, and your thoughts on it?
Yeah, sure. So the new bill is the AI Whistleblower Protection Act. I mentioned the Whistleblower Protection Act earlier. It's a little bit confusing, but that one applies to federal government employees. This one applies to employees of AI companies. And also, importantly, it applies to former employees of AI companies, and applies to independent contractors who worked for AI companies currently or in the past. And essentially what it does is it protects reporting about three different things. It protects reporting about what it calls AI violations, AI security vulnerabilities, and also violations of law. An AI security vulnerability is essentially a problem with lab security, right? In the US, it's a big worry that we're going to build these great models that are very useful and have all sorts of military applications and dual use stuff. And then some foreign government, right, not a good ally like the UK, but possibly China or something like that, would come and steal our model weights, and then they'd have our models that we built, right? Well, that's not good, right? If these are very important to national security, obviously you don't want China to have the specs for your latest fighter jet or your latest tank or your latest bomb or your latest dual use foundation model. It's important that they not have that for economic competitiveness reasons and also just for straight up national security reasons. So there's been a lot of complaints, a lot of worry, including from people at labs. Leopold Aschenbrenner is an influential writer who wrote a series of essays about this and other topics called situational awareness, in which he complains that algorithmic secrets, which are like just, I don't know, techniques, codes, anything you can do to make AI models more efficient or more like capable, and then model weights, which are essentially the weights that make up a model, right? The essence of what a model is. If you have the model weights, you can recreate it, right? Not wanting those to be stolen is an important priority for AI people. So if you have knowledge that, let's say there's a spy or a Chinese spy or something who's going to steal your model weights, or not necessarily that, but like a vulnerability that could allow a spy from another country or from a terrorist organization to steal your model weights, you can report to the government. That's important, right? That should be the case. And the law covers that. It also covers, like I said, any reporting about a substantial and specific to public safety, public health, and national security. That's important, right? If AI company employees perceive one of those, they should be allowed to report that to the proper government authorities as well. And then finally, violations of law. That is, obviously, it overlaps with state laws. I was talking about the California protection before, but it's good to have it federally because that applies to all states. And also it's like, there's different remedies now, right? You can go to federal court with it instead of having to go to California state court, which might not be as good for certain things or something like that. Essentially, what the law does.
One of the reasons someone would whistleblow is so that the problem is removed or so that the harm changes, right? And then I get that whistleblowing protection is basically designed to prevent retaliation, so it could incentivize you to talk about that harm or talk about that risk. But to me, that doesn't really make it more likely that the harm is going to go away. And then one thing the EU's whistleblowing directive does a bit differently is it puts an obligation on the employer to somewhat investigate and look into the problem that the whistleblower has talked about, and also report back to the whistleblower on what they've done or whether they think it's actually a risk. So what are your thoughts? And I know in the US, the dynamics might be a bit different on mandating AI companies to investigate reported issues.
Yeah, so this is an interesting question. And I'll say up front that I'm not an expert on EU whistleblower law, so I won't offer strong opinions on EU or UK whistleblower law just because I haven't looked into it that much. But as far as this idea of like requiring companies to follow up on reports to them, in theory, it sounds like a good idea, right? I share your worry about like, okay, you reported this, now what, right? You reported this to the government. Okay, so what, right? Like that doesn't do anything on its own. It doesn't address the issue, right? Ideally, when there's legitimate, substantial danger to public safety, somebody would do something about it. And that's not what whistleblower laws do. They just protect you from retaliation. It's like protecting some guy's job or his salary, right? It's not actually protecting the world from the rogue AI that's gonna, hurt us or whatever. But I think the theory of change for whistleblower legislation is that it reduces friction and encourages people to come forward, and that once that information is out there and the proper people have it, hopefully they'll start doing something about it, right? Using existing authorities that the government already has. Now, requiring AI companies, I suppose here we're talking about an internal report, right? You talk to your boss, or you talk to your boss's boss, you talk to somebody at your company about something that's going wrong, right? The typical case for whistleblower would be like in the securities fraud or something like that, right? Like you work at some company and you notice that somebody at your company is doing securities fraud, so you tell your boss, and maybe we should have your boss do something about it once he's aware of it, right? That kind of makes sense in the context of like maybe securities law or something. I can see an argument for it because it's like pretty well understood. I mean, it's very complex, but we've been doing securities regulation for a long time. We kind of understand how it works. I get nervous about imposing a lot of like paperwork requirements on companies because, okay, first of all, how do you decide what it means to follow up? How well do they have to follow up? Who decides that, right? It kind of depends on the nature of the report, right? We want them to respond more strongly to better reports and less strongly to worse reports. And as you impose more and more requirements, you do start to create substantial paperwork burdens, right? I think one of the selling points of the current AI whistleblower law that's been proposed by Senator Grassley is that it imposes almost no positive obligations on anyone, right? The government doesn't have to do anything. As soon as you pass the law, it's now the law, and the only thing companies have to do is they have a negative obligation not to fire people for reporting substantial specific dangers to public safety or whatever, right? So I think that's easier to get the companies on board with and to get people in general on board with because it's so unburdensome, right? People complain a lot about regulation. It's going to prevent innovation, right? It's going to stop AI companies from doing the important work that they're doing because they're going to be in a morass of what red tape, trying to check boxes and comply with stupid laws that don't really do anything instead of getting out there and building. So I'm sympathetic on some level to these worries, although I think sometimes they're overblown, right? I mean, if you're Google, right, if you're $1 trillion company or a $2 trillion company, you can probably afford with your, if you're paying your AI researchers $1 billion a head or whatever Meta's paying them now, you could probably also afford to like have a guy whose job it is to check the boxes and do the stupid compliance paperwork. It's not that big of a deal, but in order to sort of head off that political complaint that people make, which is that like, you're burning innovation and so forth, I think it's a reasonable complaint, right? You want to head it off with the pass. So one way to accommodate that is not to apply a bunch of like sort of box checky requirements that are going to be pretty hard to enforce. And I think, in my view, at the current moment in time in the U.S., something like requiring like a certain degree of follow-up would maybe be one of those. Now, if they came in with a really well-scoped law that was very specific about what companies had to do and how they could do it, that would be a different thing. I think maybe once the industry is a little more developed and we have a better idea of what kind of dangers we're looking for, that'd be more reasonable. But just requiring them to respond, I mean, it, especially if you're not dealing with a law violation, if you're dealing with a law violation, okay, maybe, people should be required to follow the law. Maybe sometimes we even require them to report other people following the law, whatever. But for just like your model is dangerous, yeah, I mean, I want them to do something about that ideally, but it's hard to require them to do specific follow-up things if you don't know what those are, and those are going to vary widely depending on the situation and so forth. So that's kind of my opinion there.
So, assuming that a whistleblower has been fired, or they've been bullied, or they've been harassed, or they've been demoted, the way that they have to seek redress is through the courts, right? And I think that would still apply through the California law and like the new whistleblowing bill. In the UK, that doesn't really work. Basically, it's very easy for a company with like a decent, medium-ish good lawyer to win. And I think like 96% of the time the former employer wins. So I'm thinking about like the US and huge tech companies and their like mammoth legal teams. How realistic do you think it would be for like former fired whistleblowers or someone who's had like their compensation removed actually seek redress if they've been harmed or fired or like victimized?
First of all, it's not just the courts that you have. In the AI Whistleblower Protection Act, the federal one that's been proposed, first you go through the Department of Labor, which is an administrative agency, a federal agency in the United States, and you make a complaint to them, and there's sort of an administrative process that you follow. And then you have the courts as a backup plan. Like, for example, the Department of Labor isn't handling it fast enough, or if, for some reason it doesn't work out there, then you can file in federal court and get redressed that way. So it's not just federal courts that you have. You also have this administrative process, which might be quicker. Court battles take a long time in the U.S. and I think in the UK as well. It's fairly timely just because it takes time to do things. It takes time to do discovery, etc. I do think that like a good whistleblower case, the ones that I'm worried about protecting, would have a very good chance of winning in the United States. I don't think the model of like, oh, this company has $1 trillion, so they can afford better lawyers, so they're going to win the case, is really that accurate in the US. I mean, if you have a good case, then there's going to be money, right? And AI employees are very highly salaried, right? I mean, some of them make hundreds of millions of dollars like that. So you could be talking about a very serious amount of money. And in that case, a plaintiff's lawyer will come along and say, hey, I'll take 1/3 of that money in exchange for your case for you. And there are some extremely good lawyers who do this, right? So for example, in the copyright cases, AI copyright cases that are going through the US courts right now, right? Of course, Anthropic and OpenAI have excellent lawyers, the best lawyers, but the plaintiffs' lawyers are killers too, because they want a chunk of that, whatever, $100 million they're going to win, right? $500 million, right? So, you do get the best law firms in the United States representing plaintiffs as well, if there's enough money on the line, right? So I am not worried about the quality of the lawyer that would represent the plaintiff in the cases that I'm concerned about. I'm most concerned about like important frontier AI type harms and stuff. And I imagine for that sort of thing, even if there wasn't that much money at stake, I feel like you could probably find a pretty good lawyer to represent you. I can imagine some problems coming up where they just crush you with their greater resources. But in general, I think the US, in part because we have jury trials in civil cases and the UK doesn't, juries are sympathetic to the little guy. They kind of don't like tech companies that much, big tech companies. So often they're willing to smack them for some money, and that'll come into play here as well.
But let's consider the case of Blake Lemoine, who claimed AI was sentient in 2018, versus, to me, a much more serious case of sort of whistleblowing, which is Timnit Gebru. And she was like a very senior Google AI employee. I think she was like director level. And she published a paper on some of the limitations of Google's models. I think this is around 2020. It might have been earlier or slightly later. Effectively, so she said she was fired. Google said she left, and there's, no one really knows which way it went, but she was kind of fired for publishing that paper. But given there's like so much hype and media sensation over kind of doomerism and like AGI or AI taking over, isn't there a risk that with a whistleblowing AI protection, like a federal protection, that there's just loads of frivolous whistleblowing going on, like AI is going to take over or AI is going to hurt kids or something like that?
Sure. Yeah, no, this is a legitimate concern, I think. And it's what you're trying to prevent with stuff like the substantial and specific bar, right? If you give too much protection, then you're enabling sort of a flood of frivolous complaints or something. Or I think the big worry is like disgruntled former employees, right? You're just mad at the company because, maybe you did a bad job and they fired you because of that, and you're mad that you got fired, or, people get mad at their employers all the time for a bunch of reasons, right? Not all of which are that relevant to public safety, right? In fact, most of them aren't. So if you make this too whistleblower friendly, you're going to enable like a flood of that kind of litigation. And so it's important to prevent that, right? And I think as long as you have good standards, those kinds of lawsuits are unlikely to succeed, right? And it costs money to file a lawsuit, right? Especially if you lose, you don't get any money back. So that's a powerful disincentive. Lawsuits are expensive. Even Department of Labor complaints aren't like completely free, right? It takes at the very least a lot of your time. So I think that should an expectation be an adequate disincentive for people. But I imagine there would be some sort of Blake Lemoine style employees who are reporting things that aren't really under the law. And the consequence there is just like, okay, I mean, they could already have done that, and the consequences are whatever they would have been before if it doesn't qualify, if it doesn't meet the law's bar. I can't really speak specifically to Ngebru's case. I haven't read her paper in its entirety. In general, it's worth pointing out that neither of those cases would have been covered by the current laws that are being proposed, right? To the extent that companies are worried about that, they shouldn't be, right? Like if you publish a paper that's not reporting to the government, right, confidentially, right, telling your lawyer who tells, the Department of Defense or whatever, hey, like this model is going to send missiles here and here. Instead, you're talking about publishing a paper publicly, or what Lemoyne did, which is, make his concerns public. That is not covered by the laws that we're discussing or that have been proposed. So if they could be fired for that back then, they could still be fired for that under the regimes that we're proposing here. So nothing has changed from that perspective.
Couldn't you consider public disclosure much more valuable to the concept of public safety? So I guess like the whole point of it is to not be burdensome to either the government or AI companies, but something is more likely to change if it's reported publicly.
Yeah, I agree. I think that there's future work to be done on scoping out a more robust system of whistleblower protections. Like the thing that started this whole craze for AI whistleblower protections was the OpenAI scandal back in 2024. OpenAI was pressuring a lot of its employees to sign these highly restrictive non-disclosure, non-disparagement agreements. And employees, if they didn't sign them, they were going to get their equity yanked, which is worth, cajillions of dollars or whatever. All these companies are very valuable. Even all the way back in 2024, they were quite valuable. And so this caused employees to get really mad, and they published an open letter calling for a right to warn about frontier AI, right? So if there's dangers from frontier AI systems, we should be able to warn the public about them, not just the government, but the public, right? And the laws that we're talking about today, the AI Whistleblower Protection Act, the whistleblower bills that have been proposed, for example, in California and so forth, are not quite that. Typically, they're restricted to reporting to the government or certain other bodies, right, or internally within the company. They're not protecting public disclosure. The reason for that is you have to balance the legitimate interests that companies have in protecting their valuable trade secrets from disgruntled former employees and stuff like that against the interest of the public in having knowledge about things that affect public safety. I think that the ideal resolution would be something like, I don't know. I don't want to sketch out the entire thing, but like you can imagine a situation in which like if it's not a trade secret or whatever, if it doesn't give a competitive advantage to your competitors, if it, et cetera, then maybe you have some protections for public disclosure. And otherwise there's like a designated government office that's like really good at responding and like really on the ball and well resourced and stuff to respond to complaints. Because I mean, okay, this is very sensitive technology. Some of it's important to national security. You can't publish everything, right? Like let's say you had a whistleblower complaint, what you did was you published the model weights. Well, that's exactly what we're trying to prevent, right? We're trying to prevent China from getting these model weights. So you can't allow them to report absolutely everything publicly because that creates risks of its own and so forth. And as long as we do have trade secret law in the United States, which I happen to think is a good idea for various competitiveness reasons and so forth, I think it helps consumers. It makes sense that we place some priority on protecting trade secrets as well. So I think those are sort of the priorities that are being balanced here. And I think that like the current laws that are being proposed are not like the final resolution of that. But I think like given how hard it's been politically to like achieve anything in AI governance in the US, I think it's a very good first step to have this sort of basic protection for the most common sense stuff that's really hard to argue against, right? It's very hard to argue that if somebody knows about a specific and substantial danger to public safety from a frontier AI system, they shouldn't be able to tell the literal police about that, right? Like let's start with that and then build on it maybe.
I'm going to kind of argue from the opposite lens now. So there are already 6 or 7 countries, and then also the EU AI office, which have AI safety institutes or offices like working with AI companies on specifically like frontier AI type risks. And then also each frontier company also has, I'm assuming, hundreds of safety engineers, if not in the many dozens. So is there really a need for whistleblowing in frontier AI? What I mean by that, if someone sees a problem, won't there be lots of other people who also see the problem almost immediately? Like, aren't there already multiple lines of defense to address these risks? And so is it really necessary to have like whistleblower protection because of that?
Yeah, I mean, I hope sincerely the answer is no, right? I hope that there's no danger whatsoever from artificial intelligence and that everything's gonna be great and that we don't need to worry about it at all. I'd be thrilled if that was the case. If that is the case, then the law essentially does nothing, and that's fine, right? We got a law that does nothing. Who cares? It costs very little to pass, right? It's a pretty short law. The cost of printing it in the Federal Register or whatever is pretty low, right? A fraction of a cent or something. If it's the case that there's no danger, then we don't need this law. But it's good to have just in case it's not the case that there is no danger. Now, in terms of AI safety institutes, right? In the U.S., it's CASE, right? It's the Center for AI Standards, and I can't believe I forgot the acronym. Anyways, in the UK, it's the AI Security Institute, AC, which is much better funded in the UK than the US. It's one thing you guys are doing better than us. But currently, their pre-release access to models is purely on a voluntary basis. I think they have agreements with OpenAI and Anthropic, which are two of the sort of, at least when these agreements were signed, were two of the more like safety-minded labs or security-minded labs. And so those companies have volunteered to give them a little bit of pre-release access to these models to check them out, right? So let's imagine hypothetically, Meta with their new superintelligence team, right, creates Llama 16, the superintelligent AI, right? They have no obligation currently to show that to the UK AC or to the US AC or to any branch of the US government, right? They just build it and put it out there, which is fine and good, right? I'm all for a culture of permissionless innovation and things like this, but it might be the case that their safety engineers are they do have safety engineer staff who are noticing things, but there also might be incredible pressures, business pressures, competitive pressures to release anyways, right? Regardless of this. Let's say that you're Meta and you've just spent $1 billion on one engineer, and your entire future as a company is wrapped up in this next model succeeding, keeping you competitive. And then some guy says, hey, like I noticed this keeps telling people how to build biological weapons, right? You're going to have a tremendous business incentive to slap a fix on it, hope it's good enough, and then release anyways, because if you don't, you're going to fall behind, right? Every few months, one of these companies releases a model that beats their competitors. This is very good for consumers, that we have this competitive, race. They're all competing with very sharp elbows to produce the best models for the lowest cost, which is great for consumers. But it might be the case that somebody notices something, like you said, one of these multiple lines of defense, and they're like, hey, like I really want to tell somebody about this. This seems really dangerous. Like I think people are going to die. But if you've got $100 million salary that you're putting at risk, ideally a good person would report it anyways and take that risk. But I think it helps to remove that friction, right? To make their decision a little bit easier, to make it a little bit less of a hassle for them to just go and report that to the authorities. I do think that there is, at least hypothetically, could be a need for it, although I hope there isn't.
So I guess we're on to our final question now, and that's if the AI Whistleblowers Protection Act does pass as it's currently drafted, like in its kind of wording, what is the realistic impact you think you project that it will have on the AI industry?
I think that in all probability, the impact will be quite low, right? This is a first step, right? Its appeal is that it's so light touch, right? It's not very heavy-handed, right, in terms of regulatory burdens or anything like that, and it's very easy to implement. So on the flip side of that, I don't expect it to be some huge game changer that really fundamentally changes the way these companies do business, which is good. I hope that it would never get used. If it did get used, though, it could be important, right? Just for getting access to information that's important to the government, right? I think my sort of overall take on AI governance is that it's very important to have information gathering resources, a variety of information gathering resources for the government. Not because I think that really heavy-handed regulation is needed right now, but because at some point in the future, if these systems become as powerful as these companies keep claiming that they're going to become, a truly like transformatively capable dual-use AI system would obviously have national security implications, and it's just good for the government to be aware of that generally, because then if steps need to be taken, which sometimes they do, right, then the government would have the information necessary to take those steps. So I think it's a good building block, along with other transparency information gathering authorities, a good building block for future AI governance efforts is what I would say.